Thank you very much, Deirdre. And so I've got some slides, but I think what I'll do is I'll go through the talking part, and then if we have time, I'll show the slides at the end. That way I won't get confused with the technology. So under federal law, uh, under the Constitution, Article 2, uh, the uh, the United States reserved the right to deal with Indian tribes insofar as commerce was concerned. It's under the Commerce Clause. And so one of the things that was quickly decided by the courts and by the Congress was that commerce included water. At the time, most of transportation, the term highway was used most often with waterways. So lakes and rivers that were navigable were considered to be uh, used for commerce. So when an Indian tribe had within its boundaries or had reserved for it as part of a reservation navigable bodies of water, then those waters uh, were regulated, were managed by the United States unless they had been reserved for some other purpose earlier. So the basic rule was that the 13 the 13 original colonies, entered the Union with with authority over the navigable bodies of water within their boundaries. And all of the later states that entered the Union, if the United States had not reserved navigable waters for some other purpose, then they went to the states. So it became a big issue for Indian tribes over the past couple of centuries whether or not bodies of water within the boundaries of reservations had been reserved as navigable or had not been reserved. So a lot of the lawsuits dealing with water between tribes and other entities have been between the tribes and states because the states have claimed waters as navigable and the tribes uh, may claim that too. So, and it will depend on the date and whether or not they were reserved. So, for instance, the Coeur d'Alene tribe had its reservation set up in the 1870s by executive order, and the tribe has always claimed that Lake Coeur d'Alene which is within the boundaries of their original reservation. They've always claimed that it was part of the reservation. The state of Idaho, on the other hand, has always claimed that it is not part of the reservation, that it wasn't clearly reserved by the United States for the use of the tribe. So the tribe sued the United States. The United States is the trustee for tribes, especially when it comes to dealing with real property. So if there is a question about boundaries of a reservation or water on a reservation, water rights, for instance, then the United States has a trust obligation to represent the tribe. So with the case of Coeur d'Alene, the tribe sued the state of Idaho, and the United States, the Justice Department for the United States, had to enter in behalf of the tribe. Now, as it happens, uh, the way the courts have ruled, the United States, when it does something like that, is its real client is the Department of the Interior. And so, as you might guess, there are sometimes conflicts where, especially with water, the Department of Interior may think other parts of its jurisdiction may make claim to some of the water. Uh, and so sometimes when there's litigation, as there was in this case over US v. Idaho, over who owned Lake Coeur d'Alene, the tribe or the state, it turned out that the United States, the Department of Justice, for whom I was working, didn't have quite the same attitude toward the whole case as the tribe did. even though the United States was supposed to be representing the tribe. So the tribe claimed all of the lake, and the United States, the Department of Justice, made the claim just for the southern one half of the lake. And that case went to the Supreme Court, and the tribe prevailed. But at the Justice Department's, with the Justice Department's claims, so the tribe owned the lake bed under the southern half of the lake. Now, so this brings us to water rights. Nobody owns the water. All there is a right to manage it. So, because water, because of the way federal law works with states, most jurisdiction for water cases involving tribes is adjudicated in state courts. Now that becomes complicated by a number of factors. So I'm going to talk about 3 different tribes where I testified for the tribe, either for the tribe directly or for the United States in behalf of the tribe. And those 3 tribes are Zuni, Coeur d'Alene, and Klamath. And there are different kinds of claims. Under the courts ruled back in about, I think, 1908, made a ruling called the Winters Doctrine. And the Winters Doctrine stated that at the time reservations are established, that they have a priority date. As George could I'm sure, probably explain better than I, in the West, water rights are based on priority dates. So the first, when a party makes a claim for water, the date that they make a claim is the priority date, and rights. So especially in a drought-ridden area, if they're here, for instance, when there's a drought, the earliest date will get the water first, and then the next date, and then the next date, and on down the line. And if you run out of water, then it's going to be the later dates that lose water and not the earliest dates. So non-Indians, there's in the West, there's a statement that's often made, which is use it or lose it. You either use your water or you lose your right. This is not true with Indian tribes. They don't lose it if they don't use their right. And the courts have had various reasons for coming to that conclusion, one of which is sometimes they've been prevented from using their rights, or their rights have never been established or adjudicated. So the Winters Doctrine is a priority date, and it basically ruled, the courts basically ruled that tribes are entitled to the water that arises in, flows through, or sometimes even flows adjacent to the reservations on the date they were established. Later, 2 other types of claims were identified by the courts. One is called the practically irrigable acreage. And so you have a tribe such as Zuni, where they're making a historical claim. They claim that, what you have to determine then is what could practically be irrigable at the time the reservation was established. And then a third kind of claim arose more recently in the past 40, 50 years, which is called the homeland claim. And that is a claim, so the tribe has the right to all the water that could be used to maintain its homeland. So now in the case of these 3 tribes that we're going to talk about today, Zuni, their reservation is right in the middle of what their Aboriginal territory was. So they, as a matter of fact, though, they claimed that all of the water they needed to irrigate the lands that they had irrigated at the time their reservation, at the time of US sovereignty, And in the 1850s, when the first United States parties reached Zuni, uh, the the tribe was irrigating 20,000 acres of corn. By 1900, they were irrigating 0 acres of corn. So their claim was for a historic use, and they thought they said they could document the use of 20,000 acres of corn. Now, uh, part of the problem with this claim was that the United States and the states had different ways of defining the term irrigating. Now, the Zunis, uh, when it rained, when I finally moved to Seattle, I found it really unusual that when it rained, people stayed indoors. At Zuni, when it rains, everybody is outside. I mean, they're praying for rain all the time. They have an elaborate prayer system, which I don't need to go into, I don't think, right now. Uh, but I did want to say, if somebody has questions, please interrupt me, and we'll deal with them as we go. Uh, so at the time, what Zuni did was, whenever there was rainfall in 1850, the water drained over the surface of the land, and so the Zunis would go outside and they would build little check dams, earthen dams, and move the water about in their fields. So if it was raining, they were out there all the time in the rain, moving the water around, making sure all of the crops got a little bit of water. They also had, and if I get to the slides, I'll show you a slide of what they called waffle gardens. They were called waffle gardens because they're laid out to look sort of like waffles with little squares. And people would hand ladle water to these crops. These were specialty crops like jalapeno peppers. Uh, and they actually grew watermelons. uh, so their claim was for 20,000 acres, but then the state of New Mexico, uh, the engineer claimed that what this kind of irrigation, floodwater irrigation, was not real irrigation, and that irrigation required canals and dams and that sort of thing. And so you couldn't really base a claim on that kind of irrigation. One of the things we pointed out was that Zuni had a sustainable system. They had been living there for over 1,000 years in exactly the same place, and they'd been irrigating crops for centuries, and they were successful at doing it. Under the United States, they went from irrigating or from producing 20,000 acres of corn to having 0 acres of corn. And there's a long story about that. But so that's one tribe, the Zunis. With the Klamath had a treaty that established their reservation. Zuni had an executive order and Coeur d'Alene had an executive order. Klamath actually had a treaty, and the treaty had language which the courts ruled said the reservation was established to preserve their fishing rights. So the, it's a long story what happened with them. They were subject to termination in the 1950s, but were reinstated. Uh, and when and this case was filed in state court, as these kinds of cases usually are, and the state cut the cases up into little smaller cases so that every tributary of the Klamath River was a separate case. And the Klamath people decided that what they wanted, because their right was for fish, what they wanted was to get their entire water right in stream flow. They wanted all of the water that they owned to remain flowing in the streams uh, in hopes of reestablishing salmon. There used to be a huge salmon run in their river, which had basically been prevented by some little dams in California down at the mouth of the Klamath River. Most of the reservation all of the reservation today uh, is in Washington, is in Oregon, excuse me, southern Oregon. And so you cross the border and get into California. So their claim was for the water that would be necessary to keep all of the species which they fished for at the time the reservation was established. And so in that, I think there were 7 different cases, 7 tributaries, and I submitted expert testimony in each of those cases to show how many fish, as best we can guess or estimate today, how many fish were present in the various tributaries. In other words, did we have people that said they saw salmon in one tributary, and did they say they saw salmon in another tributary, and so on? And there were a number of different species of fish besides salmon. The Coeur d'Alene's case was a homeland case. They basically said that not only should we have the practically irrigable lands, the land that was available potentially for agriculture. I should go back and say that the courts have ruled, and it's pretty well understood, that almost all reservations were clearly established for the purposes of turning the Indians into farmers. So it was always the intent of the United States that the people have enough water to irrigate crops and become farmers. The idea of the assimilation policy was that if Indian people would dress like white people and become Christians and live in white houses and become farmers, they could be assimilated into society, and eventually the reservations would not be necessary anymore. So you had 3 different types of claims. You had the Zuni claim, which was a historic claim for the actual amount of acreage that they had under cultivation at the time they came into contact with the United States. You had the Klamath claim, which was for all the water necessary to provide a livable environment for the fish that they fished for at the time their reservation was established. And you had the Coeur d'Alene that made the claim that they should have all of the water basically that arose in or flowed through any part of their reservation at the time it was established, because that was supposed to be their homeland and they needed all of that water for the future permanent existence of the tribe on the reservation. The Zuni claim, I should add too that the United States probably 30, 40 years ago decided to take the position that negotiations were better than litigation. And my own personal view of this is that sometimes the courts in the United States had over allocated big streams. So the Colorado River, there's no question about this, the Colorado River is over allocated. So if a tribe was to win, if a tribe in the lower part of the Colorado drainage like Zuni or Wallapai, if they were to win the rights to the water that they should have, it might not be available. And so, see if I can turn this off.
Hello, I'm calling from
Okay, sorry about that. So it was thus the Department of Interior thus had a conflict. You know, they had over allocated some of these streams. They'd given away more water than there was available, and they didn't want, and that was in conflict with trying to adjudicate the rights of tribes. So that I think that that's one of the reasons why the United States encouraged tribes and paid tribes to negotiate over a period of decades. And oftentimes, in hopes that they would take money, tribes would take a lump sum of payment instead of getting the actual water rights. And a lot of the tribes that were part of this early process did take large settlements of money, and today wish they had the real water. Some of the later tribes, like Wallapai, refused to take money and said, "You've got to get us the water that we are entitled to, and we don't care what it costs." So the Klamath, although we're in Oregon court, and the court ruled in their favor, and as a result, the three little dams called the Copco dams down toward the mouth of the Klamath River were taken out. And there is a lot of hope that there will be salmon recovery in the whole stream system. I should add that with the Klamath, even though they made a claim only for fish, I argued that they should have made a claim also for their lilies. There was a huge swamp, we would call it a swamp today, I think, where a special species of lily grew. There was about a 10,000 acre area that was partly underwater on their reservation, and they harvested the seed pods from these lilies, and it was a staple food for them. White farmers who were allowed to make entries on this land drained almost all of that swamp. There were only a couple of 100 acres left. And there are some lilies left, but not the last time I was down there, it was just a few acres. So that is lost. Today we recognize the value of swamps much more than they were recognized 100 years ago. The Coeur d'Alene won the case for ownership of the lake beds, and the last I heard, the water case is still being adjudicated. Tribe claimed that it owned all the potential water, all of the water that existed or had the potential to exist within the reservation under the homeland claim. That decision is still pending. The Zuni case was a very complicated matter because of inaction on the part of the Justice Department. The state court dismissed the case with prejudice, and eventually the United States had to refile it in federal court. So that case was tried eventually in federal court, and I think that the Zunis, and I wasn't party to the final decision, but I think what the Zunis agreed to was a partial payment and as well as real water. So these are hugely complex cases and take years. I think the Zuni case went from the 1980s and was finally settled like 3 or 4 years ago. So it was at least 30 years in the adjudication. The Klamath case, I know I worked on it for at least 6 or 8 years. The Coeur d'Alene case, the lake case, which led to the water case, and there were a number of other cases that were associated, that went from about 1990 to it's basically I just got called and asked to do something else for them. So it's kind of still going on another 30, 40 years. It's not unusual for these cases to last 20, 30, 40 years. So with that in mind, first of all, I want to see if there are any questions, if I went too fast or if I made myself clear. And then Wendy, you're gonna.
Yeah, two questions. I'm not clear on the Zuni case. Were they doing any withdrawals from streams? You talked about going out when it was raining. But what were they taking out of streams back in the 1800s?
Well, they had 2 perennial streams in the 1850s, and both of those were used for wheat, for crops that required constant source of moisture. The rest of the floodwater irrigation was all used for corn. But it should be kept in mind that this is related to their claims against the United States. In 1850, they had the stream beds float across the surface of the land
Oh,
because of actions and inactions of the United States, which was one of the claims that we made against the United States. There was a period of incision. So, for example, the Zuni Mountains, which are the mountains where most of the water comes from that feeds into the Zuni Reservation, the Zuni Mountains were clear cut and then had sheep and cattle ranged over them. And this was by military officers of the local posts. So the United States was clearly responsible. And as a result, there was a period of erosion, incision in all of the stream beds on the reservation, and the water table dropped some 40 to 60 feet. And as a result, they didn't have any water available to them on the surface of the land. When we settled that case, they took a portion of the money and created a trust fund, which they have been using ever since 1990, so now nearly 30 years, to reestablish, they're going out using their traditional system, building check dams in all the arroyos. And they have, I think the last I heard, they had 300 or 400 acres of irrigated land back. They're trying to use their traditional systems, updated as best they can with modern methods. And so it's very successful, but it'll take decades more before they can get back to where they were.
yeah, yeah. Thank you. My other question is, can you speak to what the benefit of owning half of a lake bed is?
Well, I guess so. The lake bed, the management of the lake bed means that the docks, all of the docks around the edge for all of the people that are doing recreation will be managed by the tribe instead of the United States. The Superfund, one of the first things that happened was, I don't know if you know Lake Coeur d'Alene, but the Coeur d'Alene River flows out of Kellogg, which is a Superfund site. And the state was kind of in bed with the mining companies and didn't want to pursue the Superfund site. So when the tribe had an interest in the ownership of the lake, albeit only a third has been adjudicated, and that meant that the Superfund site had to go forward, and that's about $1 billion. So, in addition, as a result of winning that case, they then sued Avista, the power company, formerly Washington Water Power, which built early on, one of the very earliest hydroelectric dams in the United States was built at the outlet of Lake Coeur d'Alene, which is the head of the Spokane River. And the tribe sued Avista for a portion of the revenue from that dam and settled for a couple of $100 million. So there was a lot of value to the tribe. I mean, of course, the Superfund site, that money doesn't go to the tribe, although they have now a major office with lots of technical people and professionals working on it on the Superfund project. I mean, there are huge issues related to how to clean up the Coeur d'Alene River and what to do, if anything, with Lake Coeur d'Alene. Many heavy metals, a very big layer of heavy metals has been deposited in the lake in the lake bed. And so there have been two different strategies that I'm aware of. I mean, there may be more, but one was to just to clear up, to prevent any further heavy metals from coming down the river and laying on top of the lake bed. That's one. And then just let the silt cover it up. And the other was, should they should they dredge it? Or will that stir things up and just spread it out in the rest of the lake? And what they have, the last time I was up there, the most recent thing that I heard was that there's a certain chemicals that are associated with the deposit of materials on the lake bed that bind with the heavy metals and cause them to rise. So they may not be able to avoid doing some kind of dredging. It may be absolutely necessary at some point as time goes on, but it's very complicated and I'm not an expert in that field. I know that they're doing the St. Joe River comes into the Lake Coeur d'Alene down in the very southern end. And there is some heavy metal down there. And so they've been doing, they did a series of cofferdams, and they're trying to show that they can close the water up over a certain area and clean it up. And that as a sort of a pilot project that's costing many millions of dollars, which would indicate the cost, the overwhelming cost to trying to fix the outlet of Coeur d'Alene River. Does that explain it? And then, so the water right, though, I mean, you're only, the lake case that went to the Supreme Court was only for the lake bed. Who owns the lake bed? Management of the water becomes the water right. And that's an entirely separate kind of litigation with a lot of different kinds of facts and different law governing it.
Okay, yeah, thank you. That was great.
Good. Other questions?
Richard?
Yeah.
Paul Smith here. I came in a little late due to computer problems, but you may have answered this. I assume the Indians' water rights are senior in every case?
No, they're not in every case. It depends on what kind of a claim they make, and it depends on the reservation. So the Winters Doctrine, which until a few decades ago was the doctrine that was since 1908 had been the doctrine that was used by most tribes, basically says the priority date for tribes in the West is the date the reservation was established. Now, in some cases, reservations are established before any white people get there. And in some cases, reservations have been established after non-Indians have been in the area for a long time. So the priority date of the Winters Doctrine priority date doesn't necessarily mean it's the first date. There are two other kinds of claims that have come into being over the past half century. One is a practically irrigable acreage claim, and this is kind of a claim that's determined while you try and figure out all of the potential irrigable lands on the reservation and figure out how much water is available. The idea being that the United States, when it established the reservations, meant to try and turn the Indians into farmers. And so they should have access to all of the water that could be used for farming. A third type of claim, which is more recent yet, is the homeland claim. This is the kind of claim that the Coeur d'Alene made, which is that they should have all the water that was within the reservation or flowed through the reservation because this is their permanent homeland.
Okay, thank you.
Yeah. Any others? I'm going to see if I can show now a few images. Are you seeing this? I'm
Yes.
trying to share the screen. So this is a map of a Zuni cornfield from 1884. And as you can see, these are the types of little check dams that somebody has gone out and made during the rain. This was a guy named Frank Hamilton Cushing, who went out and pretended to be poor and was left by an army troop there. And the Indians are very hospitable and they adopted him. And he spent several years there and wrote some incredible books. This is a drawing that was made of what a Zuni cornfield looked like. These are scarecrows and things to keep the birds away. And this is a picture, a photograph from the 1870s of what were called, what I mentioned, these are called Zuni waffle gardens. These are the specialty crops, and the Zuni River, the one perennial source of water, is just to the left in that picture. And people, mostly women, would go out and take oyas, jars, and fill them with water, and then hand ladle each of the plants in each of these little squares. If you could look inside, let's see if I can do this. If you can look, if I could blow that up right in there, you would see little squares like 6 inches by 6 inches with little mud walls around them. And this is where they would hand ladle the water. So one plant would be in each little square. And then for the corn, this is what the Pueblo looked like in 1879. And this is, they would put the corn on the roofs because it was safe there from animals. And they'd dry it there and then they'd shell it and save the corn through the winter. And they also did beans. I mentioned wheat, the perennial water, which were two of their little villages, Ojo Caliente and Pescado. They did grow some beans, and this is a couple of tribal members winnowing beans. The way they planted corn was with a digging stick. This is an old friend of mine, Chester Mahooty, and that's a digging stick that had been passed down in his family. What you do is you would hold the stick, the upper end of the stick in your hands, and then use your foot on the little brace at the bottom and put one seed in each hole. And that's how they planted 20,000 acres of corn. I knew people that still, when I was down there in the 1960s, I knew people that would walk 10 miles in the morning to their cornfield, work on it all day, and then walk 10 miles home in the night. Sometimes older people too. Okay, so I don't have as many slides for Klamath. This is, I mentioned the lily that they grew, and this is what it looked like. This is a drawing done by an anthropologist in about 1910, and the seed pod that were harvested, actually Kellogg's, the company, came out and experimented whether they could harvest these seed pods and make them as breakfast cereal to market to America. But almost all of this huge water expanse where the lilies were grown is now drained, and there are very few of these lilies left. This is a Thule winnowing basket. Almost everything they wore and used had some association with water. This is a hat made from Thules. I have a few so this is a map showing the Coeur d'Alene Reservation. As you can see, the original reservation encompassed the entire Lake Coeur d'Alene. And if you read the agreement that was reached, which established the reservation, there's no question that the United States intended that the water be within the reservation. The biggest question for the court and for the Supreme Court was whether or not this reservation of the water occurred before or after Idaho statehood. And there was a great deal of argument about that. And the other was whether or not it had been reduced. And as you can see this line here, right where my cursor is, there's a little, there was actually, it was out here, there was a little town called Harrison. And Harrison was a white town. And so when they did this survey, they did a double right angle out in the lake to preserve a harbor for the white people here. And the Supreme Court cited that as direct evidence that the United States intended that the lake beds be included as part of the reservation. The Coeur d'Alene used fish traps like this one in streams to catch salmon when there were a couple of places in their reservation where where salmon actually spawned. They don't get anywhere, they don't get close even anymore, but they did at the time. And this is the type of fish trap that they used to capture them. This is a picture, and this is actually pretty early. This is from the mid 19th century, early 19th century. This is a Jesuit priest who drew a picture of how the Indians were using the water to catch birds. They used their dogs to chase the birds into the water, and then, as you can see, they're actually out in the water trying to harvest them. So I think that's all the images I have today. Any other questions?
I have a question. I was wondering the name of the book that you mentioned at the beginning of the slideshow right there, that the guy who was adopted by the Indians.
Frank Hamilton Cushing. The one that this is from is called Zuni Bread Stuff. And basically he copied down all of the different kinds of recipes the Zunis had for using corn. They made their bread out of corn, and there were several different kinds of bread. It's a pretty amazing book, actually. It's still available, I think, through the Smithsonian.
Did he write a book about his experience living with the Indians as well, or is this the only book he has?
No, he wrote another book called My Adventures at Zuni. As I said, he came out with a Bureau of American Ethnology / U.S. Army expedition in the 1870s, and they kind of dropped him off as though they were getting rid of him. And so he pretended he didn't have any money and nobody was going to come save him, so they adopted him. And eventually he was adopted and made a member of the priesthood of the bow, which was the sort of executive arm of the tribe. And the priesthood of the bow actually are responsible for guarding the perimeters of tribal territory. And so he became knowledgeable in many what the Zunis would call esoteric knowledge, and it would be knowledge that they should never reveal to anybody. And he was publishing about it, publishing these things about his knowledge, or the knowledge he had gained at Zuni, while he was telling them that he would never reveal it to anybody. So on the one hand, he's kind of revered by anthropologists as providing great information. And from the Zuni's point of view, he was kind of a crook. I can give one more example if I can. He, as a priesthood of the bow, the priests of the bow have shrines around the periphery of Zuni territory. And every year at each of these, I think there's 6 shrines, one for each kiva. And every year they deposit at each of these shrines, what do they call a Zuni war god? It's the Zuni name is Ahayuda. And these war gods, I wish I had a picture of them. They're really striking. They're about 2 feet high and they're painted and they have feathers hanging from them. They look like a human being, and they have projecting out of their, they have a stick that is meant to represent the umbilical cord, but which collectors, non-Indian collectors, have thought was phallic. And so there actually people went out and stole these from off these shrines for many years, including right up until the late 20th century. And the Justice Department finally determined, after we negotiated with them for many years, that if somebody had one of these, it was stolen because it was owned communally by the tribe. And under the Native American Graves Protection and Repatriation Act, it was an object of cultural patrimony, is the term they used. I often said maybe they should have said cultural matrimony too, but that could have been misleading. So anyway, we actually repatriated, we found probably 20 or 30 of those in museums throughout the United States, and all of those were repatriated. And Cushing was responsible for selling many of those to those universities and those museums, and that enhanced his own professional position. But the Zunis were furious when they learned about it. And even 100 years later, they were still mad. But we were able to repatriate all of the ones we were able to identify in the United States. And there's still a few in Europe that we've been unable to have returned yet. Interestingly, the Smithsonian had 3 of them, and I went and Andy Warhol had acquired one, and when he died, Andy Warhol, he had it in his collection, and it was in a Sotheby's catalog, which I happened to see. And I called the Justice Department, said they're trying to sell one of these, and that's illegal. And the Justice Department called them, and the Warhol Foundation was actually they were very polite about it. They said they didn't know it was stolen and they'd be happy to return it. So we went back there with, I went back with a couple of Zuni war priests, and we went and retrieved it, and they bought a plane ticket for the war god. It had its own seat wrapped in bubble wrap. And it was quite a deal to go get it and fly it back home.